Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast for the American Bar Association Antitrust Law section. My name is Christina, and today's episode is Putting Equity into Section 8, a deeper dive into what increased enforcement could mean for private equity and beyond. Private equity firms have recently come under the limelight as both FTC and DOJ Antitrust Division leadership has expressed concerns over the competitive effects of private equity ownership and roll-up acquisitions. In this episode of Our Curious Amalgam, we'll explore some of the ways increased enforcement could manifest and what it means for private equity firms. Joining me today is my co-host, Jaclyn Phillips. Hey, Jaclyn.
Hey, Christina.
So who is our guest today?
Our guest today is Ken Schwartz. Ken is a partner in Skadden's Antitrust and Competition Group. He focuses on transactional and advisory matters, often appearing before DOJ, FTC, and state antitrust authorities, representing companies and transactions in a wide range of industries. Ken's practice also includes representing companies in investigations and providing antitrust counseling. Ken, given your background and the focus of your practice, it looks like we have definitely found the right person to walk us through recent Section 8 issues and recent statements on private equity and Section 8 in particular. So welcome to the show.
Thank you so much. Nice to be here.
So to set the stage for our conversation, if you're following what's going on in the antitrust world at all right now, we're living in a time of both aggressive enforcement and a lot of uncertainty. And I think both of these things are present in recent statements we've heard from AAG Cantor and FTC Chair Lina Khan that private equity firms, like Christina said, are going to be prime targets for merger enforcement. So, backing up to before these statements were made, Ken, from a historical perspective, what's your take on how regulators have typically evaluated private equity transactions?
Historically, private equity transactions typically followed Section 7 of the Clayton Act and the horizontal merger guidelines. Did the private equity firm hold an interest, own a portfolio company that was seeking to acquire a competitor, or was the PE firm seeking to acquire a competitor through a different fund or acquisition vehicle? And it was a pretty traditional lens through which they looked at private equity. But absolutely agree, over the last few years, you've seen this transition, certainly in the speeches, in the consents, condemning private equity at times as potential divestiture buyers or questioning their motives about potential roll-up strategies. So it does feel that there's a shift in the wind about how the agencies are thinking about private equity transactions. And I would note, I think that started in the last administration with Commissioner Chopra. There were frequently dissents in which he would comment about private equity purchasers. And then of note today, Chair Khan and Bureau Director Vidova worked for Commissioner Chopra. So maybe it is a continuation of that approach.
Definitely. So what kinds of issues would you say are arising in the past couple of years as we've seen a focus towards this concern about PE in particular?
Well, certainly Chair Khan and AAG Cantor have spoken out about roll-up strategies that private equity firms may employ, and whether they're able to obtain significant positions in the marketplace through acquisition strategies. Now, of course, as part of this podcast, we've certainly seen in the last few months various headlines about the role of Section 8 and whether board positions through private equity investments may be another area of inquiry for the agencies.
Yeah, so there definitely have been statements specifically about Section 8 and using Section 8 as an enforcement tool to prevent private equity transactions that raise concern with the division or the FTC. Specifically, Cantor said Section 8 enforcement has essentially been limited to our merger review process, but DOJ is ramping up efforts to identify violations across the broader economy and will not hesitate to bring Section 8 cases to break up interlocking directorates. So to back it up for our listeners who may not have had, a lot of experience with Section 8, what is it?
Sure. So Section 8, in a nutshell, is the primary antitrust enforcement mechanism that limits the service of directors and officers. So just think about it this way. It's when you have the same person serving as an officer or director of competing companies. And from a policy perspective, really what this is about is helping to prevent potential antitrust violations before they occur. Because obviously, if you're in a position as an interlocking directorate between competing companies, you could potentially facilitate the exchange of competitively sensitive information or enable coordination. So that's the policy goal behind the Clayton Act and behind Section 8's limitation on officers and directors. So a couple of key points. It only applies to competing corporations. It does not apply in vertical links. So the threshold question that practitioners ask and that companies are focused on is, do I actually have a Section 8 issue? How should I be thinking about competition?
So when we're talking about increased Section 8 enforcement, what do you think that might look like? And I think especially with respect to this horizontal versus vertical idea, could there be more of a blurring there? And should, companies and private equity firms in particular be concerned about that?
So great question. And I think we're already seeing increased enforcement, especially at the Department of Justice. The most recent second request I received a few months ago had new specifications that were focused solely on board issues, requiring onerous information about board composition and how the company addresses interlocking officers and directors in the ordinary course. So that's not in the model second request yet, or at least as the last time I checked. And it's not in the FTC second request yet, because I just got a second request from the FTC. So I think that is AAG Cantor stepping up through the traditional approach, which he identified is merger enforcement. He did say he wants to be more proactive in Section 8 investigations and searching out interlocks. I personally am a little bit skeptical about the resource allocation for that. The division and the FTC are incredibly busy right now with multiple litigations, multiple merger investigations. I would just think it's more of a resource issue of, are you really going to dedicate, staff to look for Section 8 issues, especially when there's a natural way to find it through the merger review process. But I do think, probably what Assistant Attorney General Cantor and Chair Conner are thinking when they highlight these issues in speeches is it puts people on notice, because Section 8 is largely self-policing anyways. Companies will try to figure out, do I have this issue? Antitrust lawyers like the three of us will talk to our clients about these issues. So I think it gets that message out just by having these statements through their speeches and press releases.
Yeah, and speaking of resources, in the statement that I read earlier, AAG Cantor talks about, I think, going beyond merger enforcement. And, he said, I won't hesitate to bring Section 8 cases to break this up. Do you think we'll see that, or is it your view that right now there is this issue of resources that we might be looking at?
I think there's a resource issue, plus, it's there's an easy out, which is a director can step down. So I would be surprised if the division would really want to take the step of expending resources to try to bring in action when these issues are generally handled through self-policing by clients and counsel.
Yeah. So what is the remedy for a Section 8 violation?
Sure. So Section 8 violations, you would typically have injunctive relief. Thou shalt not serve as a officer or director of that competing company. You don't see monetary damages in Section 8 cases, but the big footnote and the big concern, antitrust practitioners have around Section 8 cases is they could lead to Section 1 cases, that somehow that director was enabling coordination, was enabling information flow in violation of the Sherman Act, which of course has treble damages. So, typically you want to, if you find a Section 8 issue, you want to remedy it, and take appropriate steps so that there's not a later allegation of a Section 1 conspiracy.
So Ken, you previously described Section 8 as covering an individual, the same individual, being an officer or director of competing companies, but Section 8 also covers what is otherwise known as indirect interlocks. Can you describe what that is and how that might have particular implications for private equity firms?
Sure. Absolutely. So some interlocks are obviously easy to spot when you have the same exact person on the board of two competitors. But frequently what might happen, particularly with private equity, is private equity might have a strategy of investing in a sector, and as part of their investments, they're getting board or management rights in those companies. And they may appoint directors to those boards, but it's a different person sitting on the board of directors. This is called the deputization theory of Section 8. This is a area where there's actually been some litigated case law involving private equity. About 20 years ago, I was actually a young junior associate on the matter. Oaktree had principals who individually ran their funds that separately invested in two competing movie theater chains. And they were on the boards of those two competing movie theater chains. A third movie theater chain brought an action saying that Oaktree's presence, the two principals' presence on those boards, violated Section 8. That case didn't get passed. There was a motion to dismiss, which the plaintiffs won, but Judge Lynch here in the Southern District, articulated the deputization theory, said it is a viable theory that Oaktree could be represented on both those boards, but really did hold up a standard that suggested it's pretty hard to meet. Were they serving as basically puppets and instrumentalities, the two directors, on behalf of Oaktree? And it was that type of standard that Judge Lynch would say could lead to a violation of Section 8. But if they were otherwise acting in their own independent capacities, as representatives of their funds, Section 8 liability should not attach. So that case has become instrumental and certainly something we all work with our private equity clients to make sure we're on good ground.
Do you think that the recent statements and focus on Section 8 and private equity could lead to any sort of, expansion of how Oaktree is interpreted?
I think that's a great question. I think that you certainly are seeing the agencies wanting to bring every tool in the toolkit to enforcement. So, given the statements by AAG Cantor and Chair Khan, I think they might be more expansive in how they may think about these issues. But ultimately, Section 8 case law is pretty established. The facts are pretty established. So I wouldn't really see a groundbreaking approach on Section 8. I think you would be looking for more tried and true examples.
So given that, this is pretty established and companies have been thinking about how to deal with Section 8 already, what do you think private equity firms or other companies really have to worry about when it comes to this renewed focus? Is it really the burden of having these additional second requests or, the investigations that might happen?
I think the biggest issue that jumps out at me might be from the recent JAB veterinarian consent, because you're seeing the commission add in prior notice and prior approval provisions, with the majority suggesting that those fairly onerous terms are in part motivated by the fact of who the purchaser is here, in that it's private equity. And just by background, a prior approval provision is a term in a consent decree where if the merging parties are required to enter into a consent and divest assets, you are basically giving the government a veto over your ability to acquire additional assets, typically in that market. But with JAB, we saw much more expansive use, not necessarily narrowly tailored to the affected markets in those consent decrees, local markets for veterinarian clinics. It was a more expansive approach. And Chair Khan's statement about this suggested it was really because it was a private equity purchaser that she was, advocating for this more expansive relief.
I think that prior approval issue is something that, that's been spoken about in the statements as well. And, do you think based on the JAB case that that's something we may be seeing more of?
I actually do. And I worked on a matter in 2020, right before the change of administration, where we did have a narrow prior approval provision, but the FTC staff did tell me this is going to be the future, because prior approval had fallen by the wayside in the mid-1990s, and so it's now making a comeback as again, another tool in the government's enforcement kit, but certainly a tool that gives the FTC a lot of leverage through that.
And let's break that down a little bit more specifically for private equity client, right? So there's the actual act of having to get to notify and get approval for a transaction that may or may not be HSR reportable, right? But how does that position a PE client going forward? What are you thinking about? How are you advising your client about whether to accept prior approval and what that means for them going forward?
It's a great question, Christina. I think the threshold issue you probably would want to think about is, do I have to account for this in my merger agreement, in my efforts provision? What am I signing up for in terms of the amount of relief I'm willing to take on here? Because, you can understand what the impact is of being required to have to divest certain assets to get a transaction through FTC or DOJ clearance. But if now there's the potential that there could be, expansive or onerous prior approval or prior notifications that could impact your strategies going forward, are you committing contractually to sign up for that? So I would see that as an issue that clients are going to start to really think through, especially if JAB becomes the norm of how the majority at the FTC is going to think about consents involving private equity.
With respect to, the enforcement toolkit that you've been referring to, is there anything else notable that you can think of that we, haven't spoken about that's really been a shift from before, the past couple of years until now?
Well, obviously, you have the Biden executive order with a whole of government approach to antitrust. You are certainly seeing more collaboration between the antitrust agencies and federal agencies. It's a time of heightened sensitivity and heightened scrutiny, both for mergers and acquisitions, but also on the conduct side. So, that's how I would think about, where the government's head is at these days. Certainly wanting to be aggressive, wanting to be out in front, and wanting to have, their voice heard.
So Ken, we spoke earlier, both of us mentioned the word roll-up acquisitions, particularly in certain industries. And there's the traditional way of looking at that, which is the additive acquisition anti-competitive? There's also been a lot of noise around sort of the macroeconomic impact of having certain companies roll these entities up, in particular private equity, and what that means for the overall strength of certain markets or industries. Do you think there's any grounds for the agencies to bring cases on those theories, or do you think that there is a theory there of harm?
The short answer is no. That I think that Section 7 in the case law would require a court to look at the transaction in front of them, the market structure in front of them. I don't think you can have a judge take a crystal ball and say, well, there might be additional transactions you're going to consider, or your documents highlight you may be taking steps to do additional deals. Therefore, that's a basis to enjoin the present transaction. I don't think Section 7 would reach that far. But the government certainly is incredibly aggressive in looking for novel theories and wants to break the mold.
We've talked a good bit about what the future might look like, but just at kind of a high level, what's your view on where we're heading and what private equity firms should be thinking about, and I guess more generally what companies should be thinking about when doing a transaction and having these statements and renewed focus on Section 8 and P in the back of their mind?
I think you're going to see more aggressive enforcement and investigation. I think you're going to see the FTC in particular continue to think about what types of provisions they can work into consents to give them more leverage going forward. You'll see prior approval, prior notice. We've seen provisions recently requiring the divestiture buyer to hold the assets for a certain amount of time. I think you'll see a lot more engineering and consent and not just, pulling the last, the precedent off the shelf and changing the names. I think you're going to see a lot more tailoring and crafting in inclusion of provisions that may be, less friendly to the emerging parties or the divestiture buyer than we've typically seen. I think you'll probably also continue to see more Section 8 inquiry in second requests. The way the DOJ is currently doing, I would not be surprised if the FTC picks that up as well. And I think you're going to continue to see more headlines. I think that the DOJ and the FTC have been very active about getting their messages out. We're all talking about it, and I think that they see a net benefit to getting their message out of where they're going to focus their attention.
Yeah, can agreed. And certainly a place where we all struggle to advise clients on is it's a changing landscape. But we really do appreciate your thoughts today. Before we let you go, we do ask all of our guests a couple of more personal questions so our listenership can get to know you. So first, if you could tell us something about yourself that we wouldn't know about you if we only knew you professionally.
Something about me. I love to cook. That is my most relaxing time of day is making a great dinner for my son and myself.
And is there a particular cuisine or dish that you're most proud of?
I make a great paella.
Ah, okay. Everyone is officially invited to Ken's house for paella the next time you make it. And the last segment, what we call the Curious Hat.
And now it's time for the Curious Hat.
So Ken, if you can pick a number 1 through 10.
7.
Tell us about a teacher who had a major influence on you.
Sure. I would say my mentor as an antitrust lawyer was Neil Stoll, who I always thought of as the Charles Oakley of antitrust lawyers, a tough guy, an enforcer, but as smart and sophisticated as they came. And he just taught me the ins and outs of antitrust. And I was lucky to learn by his side for a good 5 years as a young associate.
Where did you meet him? Also
he
at
was a Skadden partner. He retired about 10, 12 years ago.
Great. Well, Ken, thank you again for your time today. And to our listeners, thanks for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.